pleased again to be joined by Ian Quayle and also by John Logan, our senior underwriter in Scotland, and by my colleague Liz Birrell, who deals with client relationships in Scotland. So that's great there. Did I just say Northern Ireland, John, by mistake? But hey, so it's Scotland. Sorry, I was just looking at something else. So yes, John is our head underwriter in Scotland. Liz deals with BD in Scotland as well. So Ian, another month has gone by. More topics, more problems for lawyers. Absolutely. And also understand you're now working on a actual in-person conference in Scotland that you've got some details of you'll be giving later.
Yeah, we are. Once again, massive thank you to Stewart Title for their support with regard to all things that we're doing up in Scotland. Because of the popularity of the forum and because of feedback that we've had, we've decided to organise an event. I think it's in February. You'll see in the slide in a moment or two the intended date. So it'd be lovely to have feedback from attendees or from firms to see who would, if they'd like to attend a face-to-face event, and indeed any topics that they'd like exploring. But Stewart Title are, of course, very keen to promote their services and indeed even keener to promote the goodwill with regard to the legal profession generally, conveyancers in particular. So that's one of the projects that we've been given, which is great. As far as these forums are concerned, again, just to emphasise for anyone that hasn't attended before, these are your events. So as far as the conversation is concerned, I will start it and start the ball rolling. But if anyone has any burning topics that they would like to put to the forum this afternoon, you're more than welcome to do so. Equally, if there are any topics that you'd like us to examine in connection with future events, please drop us a note and we'll ensure that we cover those off too. Because the important thing to understand and the important thing that Stewart Title have instructed me to ensure is that these are your events. So as I say, it's not me droning on about different things. It's you talking to one another, sharing with one another problems and issues. So if you have any questions, have any queries, anything you want to discuss, use the chat facility. We can also ensure that the microphone is turned on so that you can speak to me directly or indeed speak to others. We do record these sessions, so if you have to cut out and come back or whatever, I'm more than happy to ensure that a copy of the recording is made available to you. So first things first, welcome from Stewart Title. Contact addresses shown on there for Liz and for John. Important to understand and appreciate that we don't have Robert from Terra Firma talking to us. He has spoken to us in the past, but I am the coordinator as far as today is concerned. And the topics that I would like to explore are these. First of all, the Registers of Scotland backlog, to see how people are managing, to see if anyone's got any views or any issues. To talk a little bit about client complaint handling and some issues relating to it. To talk about a case of McNabb and Gilmore. I don't know if you saw this, about implied servitudes of access and about access issues. Quite an interesting case that I want to share with you or want to look at. And then we've got Ardnamurchan Estates against McGregor, an issue with regard to plans, bounding titles, etc. that again I thought was interesting. Ardnamurchan is always very close to my heart because every January my partner and I go to the Isle of Lismore for a week. You may ask, the January on the Isle of Lismore doesn't sound particularly appealing. The solitude is lovely. The fact that you can get to places very easily because there's no one there is equally lovely. So every time I've been on the Ardnamurchan Peninsula, we've been there and there's only been one or two cars on the road, where people tell me in the summertime it's like a car park with the amount of people going to and fro, along with problems with the ferry. Anyway, enough of that. Do use the chat facility for questions. First thing, or comments. First thing, Registers Scotland backlog. What's the position at the moment? How are you finding things? And is it causing problems for you? And are you getting client complaints, or are clients happy? And do they understand the problem with regard to registration? So that's my first question that I put to attendees today. So Rebecca, Hannah, Debbie, hi Debbie, Charlotte, Jonathan, anybody else? Anyone encountering any difficulties or issues? Luden as well, and Nigel. Anyone got any problems or anyone encountering any issues? We've got the Register of Scotland coming to speak to us. I think it's sometimes either October or November. And certainly the Land Registry in England and Wales, whenever we get them attending anything, boy, do they get a bit of flack. And therefore, what I'm attempting to do is to see if there's going to be any issues or problems, or you're encountering any issues or problems at the moment that warrant discussion. So anyone got any comment to make about it? Certainly, I was reading an article, I'm just trying to pull it up on the screen, to be honest with you, about sort of promises that have been made that by December 2024, the backlog would be alleviated. I'm just interested to know whether, in your view, they have been successful with regards to that yet. So anyone got any comments, anything to like to make about it? Or are you all of the view that all is well? Again, I'm not seeing anything in the chat. I'm just checking that we've enabled the chat to make sure that people can in fact participate. So I'll just pull that up again on the screen just to check. I can't see anything at the moment, but I am seeing things now. So anyone got any comments about that? Okay, there doesn't seem to be anything in there. Next thing about, oh, right, here we go. Right, here, I thought, I tell you what, I was just about to fall off my chair on the basis that everything was going well. David, waiting for a title sheet for an application lodged in 2019. Registration quicker, but anything size, yeah, it's taking ages. Yeah, very erratic with no apparent reason. So have the register been good enough to volunteer what's happening other than that article? And I forget where I saw it, but there's an article sort of explaining the position and the promise that had been made, I assume, to government about what they were doing to try and alleviate the problem. Right, erratic, yeah, with no, I tell you what, Robert will sort of verify. Robert, this is exactly the same thing that people say about HM land registry in England and Wales, isn't it? It's sort of a mirror image of what we constantly get about the land registry.
It's exactly. There are some which, for no apparent reason, appear to cause them great headaches.
Yeah.
And you seem to constantly being put to the back of the pile. And some simpler ones have been done quickly. But yeah, it's. There is erratic is probably the exact word to describe it, unfortunately.
And the problem, as Nigel says, with it being erratic is, what do you say to clients? So I was talking to someone, and they told a client it could take up to 2 years for an application to be registered. So they tell the client that, and then in the next breath, what they say to the client is, "Oh, surprise, surprise! Your application's back sort of 3 weeks later." And I mean, that's just absolute madness. So it's even worse, isn't it? Where you have that sort of scenario, because the client thinks, well, you know, you're an idiot. You told me it's going to take 2 years and it's back straight away. So can you expedite, and does expedition help anyone? Charlotte? Or are you able to spot a transaction and say, look, we're likely to have a problem with it? See, one of the beauties of the English system is you can apply for voluntary registration. And so sometimes what I say to practitioners is, look, apply for voluntary registration before the transaction begins. The problem with that, of course, is often you're not in a resi context. You're not going to get instructions about, well, I'm thinking about selling my house. You're going to get instructions because I'm selling my house. And therefore, voluntary registration doesn't work. Right, okay. So, Charlotte, on this issue about not urgent enough, can you give me an example of where the register has said it's not urgent and where they said it has? Loudon, I hope I'm saying your name correctly. If I'm not, kick me, please, or give me a virtual kick. A couple of outstanding where we managed to get the next by means of letter from the purchaser saying that can't report the lender as good. Yeah, that's what I thought. But I wondered whether you'd need more than that. You know, there was a risk of the purchase falling through, or there was an issue with regard to the purchaser's work. You know, there were sort of additional factors other than a problem with regard to a standard purchase. The applicant is suffering. Yeah, that's what I thought, David. That's what I thought. So it'd be more than, you know, you're holding up the purchase or you're holding up our sale. Okay, so if we look at this then, there's not a great deal of positivity we can extract. So do you think, does anyone have the inside track as to whether or not December 2024 we can have a party? All right, Loudon, thank you. They readily accept that as a ground for expedition. That's fine, thank you. Very good. Okay, well, as I say, we've got someone coming in October, or November. I think this might be November. We'll be able to ask the question, where are they and how they're getting on. Charlotte, thank you. Yeah. Yeah, transactions falling. And Charlotte and Loudon, where you do that, how quickly do they then jump? So how quick, if we're expediting, how quickly is the expedition? Anyone? Five days, sometimes quicker. Okay. Back in less than a week. That's really good, isn't it? Okay. And how many of you are getting earache from clients about this? All right, deal with it in a week or a fortnight. Okay, okay, Nigel. Yeah. Because again, in England, you'd have to say the vast majority of clients are completely unaware that this is a problem. And what therefore happens is they ventilate their anger at you. Yeah. Okay, David. But again, I'm asking the question, are clients aware of it? Or are you the sort of purveyor of bad news when this becomes an issue? Interesting. Interesting. What I'm going to do is I'm going to drop the Register of Scotland a note prior to their attending, and I'll see if I can get some more data on this for you, and happy to share it as soon as I get it. Okay, right. Yeah. So you highlighted when you're onboarding the client, Charlotte. Yeah. Yeah. Okay, David. Yeah, I think that's the key as well, isn't it? Just to make sure clients are aware. And again, all right, Charlotte, where are you based? Up north, Charlotte, are you? Yeah, right. I thought so. Okay, right. Yeah, yeah. And do you have someone in the Registers of Scotland that deals with a particular area, Charlotte, so that is more familiar with your issues? Because again, the Land Registry in England used to do that. They used to allocate officers or teams for firms or for areas, so they'd know about the idiosyncrasies of Caithness or Sutherland or whatever. Right, complex. So does it always go to complex registration, Charlotte? Because if it does, that's good news, isn't it? Yeah, all right, okay. Because that's the other problem. I think that, like what David was saying and others were saying earlier, sometimes the problem is you're getting varying officers with varying degrees of experience and knowledge. And therefore, that's why you're getting discrepancies. Sometimes it's also due to workload, etc. Yeah. So, yeah, I think as long as you're letting clients know about it, it makes life a little easier, it doesn't make it easy, but it makes it a little bit easier. Tell me the next question, really relating to that. What's business like? What are people finding? Again, interesting. I've been talking to people last month or so all over the place, and some are saying really busy. Others are saying exceptionally busy and unusually so for the time of year. And other firms saying, hey, we're quiet. Now, I put quietness down to the election, uncertainty with regard to the election, cost of living, and sort of summer. Thanks, Nigel. Thanks for that point. Good practical point. Well done. So, yeah, going back to this work, what are people finding? So, Charlotte, I'm in Caithness, what are you finding? Are you busy? But I was talking to someone who was saying, they were saying they're quiet, very busy in East Lothian, Cheryl. Right? Yeah. Okay. Yeah. Yeah. Well, that's good, isn't it? And what about West Coast, Glasgow? Anyone? All right, Loudon, Helensburgh. Yeah. Right. Okay. That's good, isn't it? It's good. I mean, the downside of being really busy is in the summer when you've got people on holiday, it becomes rather than busy, it becomes a bit manic, doesn't it? But there you go. Okay. Right. Next thing. Right, David. So why did you put June down to being quiet, David? I see. That's the thing. Someone far more into this than me was saying he couldn't get the vagaries of different months. What he did say is that he showed me some statistics, both for England and Scotland, that showed there were more properties being put on the market than at the same time last year, which was interesting. But it seems to me that the sort of normal seasonal peaks and troughs doesn't happen anymore, other than the sort of Christmas, Easter time thing. Yeah. Yeah, okay, picking up now. All right, that's interesting. Thanks, David. Okay, next thing I want to talk about is client complaint handling and how we deal with complaints. First question to everyone, what do clients complain about? Is it fees? Is it delays? Is it ineffective communication as seen or not seen by the client? What are clients bleating about? All of the above, David. Right, okay. Yeah. And as far as that's concerned, as far as complaint management is concerned, what's your view? I mean, people seem to be saying all the time that, regard client complaints as a sort of positive thing. Now, how on earth you can see it in positive light, I don't know. But what they do emphasize, and I have some sympathy with this, is to try and make sure that the complaints process does not become a justification for yet further complaint. And it's a tricky one, isn't it? Because sometimes clients' complaints are completely unjustified, and therefore you feel entirely justified in treating the complaint with some disdain. Other times, the actual complaint has some form of explanation that is outside of your control. And again, difficult in that situation to have sympathy for the client. But I think it is important that we try and look at complaint handling positively. Does every firm all have a policy of dealing with complaints? And does that policy involve the matter being referred to a partner or a head of department within the firm? Because I was talking to a firm recently and they were saying that they were looking at complaint handling and changing things around and saying, right, first port of call, the person against whom the complaint is made should attempt to address it and deal with it. And I sometimes think, well, are we not sort of creating a red rag to a bull type of situation if we do that? Is it not better to try and take the personalities out of it? But at the same time, I do see how, if we're trying to de-escalate and trying to resolve things and looking at positively, it might be appropriate for the person against whom the complaint is made to see if it's possible for the matter to be resolved, whilst at the same time notifying someone else in the firm. Yeah, a client relations manager. But as far as that's concerned, Loudon, I agree, you have to have that. But I'm just saying, right, we have a client who makes a complaint, and let's call it a low-level complaint, okay? Does the client relations manager, does anyone in compliance in the firm, does the head of department say, well, all right, I'm logging this, okay, but I've asked whoever was dealing with the file in the first place to resolve it. They will be in contact with you. If it isn't resolved, then either they or you can come back to me. Just wonder how we deal with it, because I sometimes think that if it's sort of sent up to the client relations manager, things can sort of escalate and get out of control. As I'm telling you about this, I remember a matter years ago where a firm had a nightmare client, just a nightmare client. And the client seemed to take great delight in being critical of the fee earner involved in the transaction, but then being highly critical of everyone else that then intervened. And at the end of the day, the sort of the crux of the matter was that the client was saying, well, had the person that I was originally making the complaint about actually dealt with it completely, then all the other complaints wouldn't have arisen. And I thought, well, hey, am I going mad or are they going mad? David, Supervising partner responds to client and alert complaint of possible comment. If it isn't resolved at that stage, then complaints partner gets involved. Yeah, we've got to have a system, but I think we do have to look at it positively. And I think that one of the problems is, that we're scared to say something's gone wrong on the basis that there could be a claim. But when you look at sort of complaint handling advice, one of the things is to try and be positive, and if an apology is warranted, to make it. I think the big thing is to say to a client right at the start, you're making a complaint. What do you want us to do? What would be a successful resolution to the matter that you're complaining of? What exactly are you after? And I think saying that, not in those sort of hard terms, but in terms that are more accommodating, that can often resolve things. But the number of times I've seen where a third party becomes involved, the matter sort of intensifies, is quite bizarre, really. Okay. I was reading another article from someone about complaint handling, and I might get them to come along at some point in the future to have a look at it. Interesting. There's a case, right? Yeah, I'm just looking at it now, really. Kate, in the course of session, where a complaint made to the Legal Complaints Commission. And the Legal Complaints Commission does have some good guidance for dealing with complaints. What I always say to people is, if there is a complaints commission, make sure that you comply as best you can with their recommendations. And when a complaint is made, therefore, at least you're in the good books on the basis that you've done what you say they need to do. I used to do loads of work and training with the legal ombudsman in England about client complaints. So I've seen it from the sort of the side of the complaints body and their role. And one of the things, as I say, that I learned very rapidly from that was this idea of where a firm has complied with recommendations of the Ombudsman or the Legal Complaints Commission, the Commission, the Ombudsman tend to look at the stance of the firm far more favourably. And sometimes, going back to what we were saying a little earlier, no matter what you do, the client's going to complain. My first boss, I don't know if I ever told you this, said on day one of my training contract, the secret of this game is to spot the nightmare client and the lunatic and make sure you don't act. You just, for whatever reason, think of an excuse not to get involved. Because he said, if something appears to be trouble or a client looks like trouble at the start, it ain't going to get better. The worst that'll happen is it will stay the same, and the likelihood is it will get worse. And that was a guy that when he was giving me that advice had been in practice over sort of 40 years or so and seen just about everything and everything. Probably one of the best lawyers I've ever worked with. Another thing he said to me, I always remember again, day one, I expect you to make mistakes, right? I expect if you're busy and you're working hard, you will make mistakes. We all do. The secret is only to make the same mistake once, and two, if you have the slightest inkling that you've made a mistake, let me know straight away, and let's see if we can resolve it. And I think that was very, very positive advice. Okay, right. Going on from that. Did you see that case just recently about Japanese knotweed? Can't remember the name of it, but again, the issue of Japanese knotweed and now bamboo is got everyone sort of jumping up and down, hasn't it? And concerned. And there was an interesting case, wasn't there, in Scotland about infestation and whether Japanese knotweed constituted an infestation. And the court held that it was, obviously, and that there was liability arising from a failure to disclose it. Did you all see that? There's been cases in England concerning Japanese knotweed, one in particular, where it cost £37,000 to eradicate it. And I was reading something, still ongoing, Nigel. There's also, I think now, the potential for certain types of bamboo to be the next or the equivalent of Japanese knotweed. There's also been cases where, allowing Japanese knotweed to grow on your land and then to go on to adjoining land and to sort of grow there constitutes nuisance. And again, the problem with Japanese knotweed, and to a lesser extent bamboo, I suppose, is you're not likely to know it's in your garden, are you? I guess bamboo you would, but I think Japanese knotweed, who knows what it looks like? And even if you do know what it looks like, who on earth can be able to say on every sort of inch of ground Japanese knotweed isn't present or hasn't been present in the past? Okay, next thing I wanted to talk about was this case of McNabb and Gilmore in implied servitudes of access. Did you see this case? Really interesting case concerning a farmer, I think it was, up in your neck of the woods. I think, was it in Caithness or somewhere? Charlotte. Let's have a look at the address. Sure it was somewhere up north on the A862 involving the Highland Council. And what happened is there'd been some road construction work involving a new section of A862 parallel to an old road, and the old road became a cycle path. And you had a farmer who had access to one of his fields from the old road, and the issue was he now had no direct access from the new road into the field. So he brings proceedings relating to... Yeah, well, that's... Sorry, David, we're going back to Japanese knotweed. That's the problem, I think, with who would know what it was? Clients doesn't know it was. So how do you deal with that? The standard clauses, I know, David, require a seller to disclose it, but what do you do? I mean, again, I've been looking at some case law in England, and what they're saying is your client is obliged to make reasonable inquiries before answering a question or making or being able to determine whether to disclose or not. So what are reasonable inquiries with regard to Japanese knotweed? You get a gardening expert in to have a look. Well, even if they did, how are they going to know? Because it seems to me that you might not be able to identify that it's growing underground from a neighbouring property. Nigel, selling you was there maintained not enough to constitute an infestation. Yeah. Interesting point, isn't it? So David and Nigel, right? So how do you deal with this? If you're acting for me and I'm selling and I'm risk averse with regard to a claim, okay, and the standard clauses require me to disclose if they're aware of it, do I just simply say I'm not aware of it? Do I have to undertake some form of investigation? Do I say I'm not an expert and I haven't investigated? How does that work? So I'll leave that open for David and Nigel and indeed anyone else to comment. The McNabb case is Dingwall. All right, thanks, Ian. Yeah, take the response. But David, you warn them. You say, hey, look, if you get this wrong, there's a potential problem here in connection with breach. And thanks, Ian. Yeah, Dingwall, correct. So I think the important point with regard to the implied servitude case is that the court was looking at whether or not there was an agreement between the farmer and the council with regard to access, and there didn't appear to be. And then as far as this implied right was concerned, they were saying, well, and this is again a point that I'm very familiar with, if it's implied, you're looking at what the original use was. And I think the original use was access to a field for agricultural purposes. And I think what the claim involved was the intention to use the field for commercial purposes. And that sort of intensification argument invariably means that the implied servitude is not sufficient to allow the intended use. in this case, I think the argument was, well, the council should have been aware that a planning application had been submitted. Yeah, so far as the seller is aware. Now, Nigel, with regard to that, again, in England now, they're talking about, well, if you're going to say that, you've got to have undertaken reasonable investigations. Right. Yeah, David, I think clients will, again, we're back on Japanese, not we, which is fair enough. Again, I think clients will say no, won't they? And I mean, for two reasons. One, there might be a genuine lack of awareness. But the other thing is, with regard to these sorts of questions, the more and more publicity there is relating to them, the greater the client will be thinking, well, if I tell the truth here, I'm going to stop the buyer proceeding with the purchase, right? And if I have to disclose my knowledge or my lack of knowledge in every subsequent potential sale, someone's going to come along and say, well, I want a reduction in the purchase price. So either of those things means that there is an incentive, potentially, if that's probably the wrong word, on a seller to not tell the truth. And, or another important point, as far as the seller is concerned, the seller's response is going to be, I'm not aware, or I'm not so far as, no, so far as the seller is aware. And again, the problem there is, well, what's the value of that to a buyer? Yeah, so you've never had that, David. Anyone asking further about knotweed? Yeah, but the point I'm making, David, is the more publicity there is about the potential for liability or how invasive or how costly it is to eradicate, the greater likelihood of a buyer wanting to know more. And it seems implicit that the process requires the seller to be more and more cagey or evasive in providing any useful or meaningful response. Okay, right. Anyone else got any topics to talk about? Because I've got another one on bounding titles and titles generally that I wanted to talk about. Boundary issues I wanted to talk about. Next time, I'm going to talk about tenement boundary issues. I think someone raised this in a previous forum, and I want to spend a bit of time looking at tenement boundary problems because it seems a fairly common problem, not surprisingly, to be honest with you. But I wanted to talk about boundary issues. And again, we're dealing with, I think it is, Nigel, I think it is a right of way. Well, the psychopath may well be a right of way for sort of general access, but was it an implied servitude of access for the field? I think it was the question, Nigel. David, I agree with that point. Anyway, the issue with regard to boundaries and the land register, and this requirement for a satisfactory description of the property to allow the keeper to accurately represent the property on the map, Ardnamurchan Estates against McGregor is an interesting case, isn't it? Because what you had here was a dispute about where a boundary arose, and you had various documents of title that were, in essence, inconclusive. And what I thought was it might be worth looking at this to see what we can do to identify boundaries. And again, it's very interesting in that as far as the Register of Scotland is concerned, they're looking at the words that are used within a document or deed. Every boundary of a property must be clearly described by reference to compass orientation, description of adjoining property, description of the boundary itself. Might be necessary to look at county series maps for confirmation of the position of the boundary. Now, I thought that county series maps were inconclusive and couldn't be relied upon in connection with boundaries. I thought they were a guide or an indicator, but weren't or couldn't be relied upon. Does anyone know the answer to that? And I mean, the problem with boundary features, stone walls, tree lines, etc., is what happens if they've changed over time. So, I mean, what I see when there's boundary sensitivity is use of national grid coordinates. I don't know if anyone's seen that with regard to a new boundary in a rural area. If we're using measurements, they can be given in metric or imperial units. Well, yeah, fine. The problem with measurements and boundaries is that you've got to have evidence of where the measurement was taken from and taken to. I think it's Germany or somewhere in Europe. There's a requirement to have a concrete sort of post in the ground, and its measurements are taken from that post, so that therefore a measurement not only describes the area of land involved, but also because of the location of the post, it describes its location on the ground. I've had disputes over the years where a site has been pegged out, and a dispute has then arisen as to where on the peg the boundary is. Is it the centre point? Is it the western face or the eastern face of the peg or the stake? I mean, that's how ridiculous it can get. In this particular case, it was, it wasn't just a matter of centimetres. There's quite a bit of land that was subject to dispute. As far as bounding descriptions are concerned, I think the Register of Scotland give you guidance, don't they, as to what is acceptable and what isn't. But I'm told that applications can be rejected and are being rejected as a consequence of an inability to determine the extent of the land that's being sold. And I was just going to show you or refer you to a description that was unacceptable. Can I ask a question, everybody? Would you, if you were selling a parcel of land, have a plan prepared by a chartered land surveyor? Charlotte, up there up north, if you're selling in a bit of farmland or whatever, would you have a professionally prepared plan? And if you would, what sort of cost have you incurred or seen incurred? I've seen a chartered land surveyor charge £4,000 for the production of a plan, but the plan was necessary because the boundaries were intricate and the location of the boundary significant to the parties, and therefore the expense was thought to be well worth incurring. But again, that would sting a bit, wouldn't it? Yeah, the problem I have with the OS map, David, however, is that map I know they use digital mapping now, so they're better than they used to be, but I'm sure there's a disclaimer, isn't there, with regard to OS maps? That's really interesting. Miller and Bryce prepare them for £150. I'm going to get someone from Miller and Bryce to come along, but I didn't realise they were able to do that. Loudon, is that sort of in a standard resi transaction? First Scottish do as well. Yeah. Okay, I'm going to see both Miller and Bryce and First Scottish shortly to discuss a number of issues. But the point I'm asking, Loudon, and indeed Nigel, is that would be on a sort of straightforward transaction. It wouldn't be where a sort of sale of a plot where the land is being subdivided, would it? Or would it? Because it seems that's crazy. If my bit talk about £4,000 or £5,000, and you're saying, well, £150 we can get the job done. Happy days, They do in the hell. So rural property, £150 plus VAT. That's fantastic. And does the register the register happy to accept the plan? I assume they are, yeah. So in those circumstances, and indeed everybody else, it doesn't matter so much about the description then, does it? So you'll just say that the property is delineated or defined by reference to the plan and leave it at that. Right, so this description still remains important. Because it's interesting, I was just reading a case yesterday, and the court was giving you a sort of checklist of things to do. First of all, look at the description. If the description is clear, then you don't have to look at the plan, you don't have to look at anything. All right, I get you, Nigel, that's fine. Then it was saying if the description is ambiguous or vague, you refer to a plan. If the plan is ambiguous or vague, you try and identify what was intended when the boundary was created. All right, Loudon, I get that, yeah. Because I think, the creation of a detailed description could be quite a complex task, couldn't it? Loudon, everybody else, what happens if you have an intricate boundary? So again, I'm going to talk about tenements next time, but if we're dealing with a tenement or a really intricate boundary in, say, an urban context, would a plan that's produced by a search company meet the requirements of the register? Or would you have to have a more detailed or a greater scale plan in those circumstances? Right, okay, yeah. And I guess then it's more than £150 because I guess someone's going to have to come out, yeah? The plans report, okay, yeah, get that. Good. Okay. I noticed the register of keepers says that if the bounding description containing a previously recorded or registered deed for extent in your application doesn't mean the criteria that the keeper has imposed, then the application could be rejected. So again, it's a pretty big deal, isn't it? Okay. Which leads me to another point. I've mentioned this in the past about client inspection. Do you recommend to a buyer client the significance and importance of inspection and refer the client to how the property is described or shown on a plan and ask the client to confirm that what they see when they inspect is consistent with how the property is described or consistent with a plan? Anybody? Just waiting for that. Always, yeah. Okay. And Ian, highlight to the client the significance of the client reporting to you anything that's inconsistent with documentation or plan. Thanks, Charlotte. Loudon, you don't need a more detailed and therefore expensive plan for a complex site. All right, Kate, thanks for that. Happy with any deed plan. David, and description? Or just plan? Because again, my experience of conveyancers in England and Wales, they highlight to the client the plan and don't necessarily highlight how the property is described. And given what we've said, that the registered keepers, the courts are saying it's the description that's more important, and Nigel, both, if there is both, and Nigel, that there's consistency between plan and description as well. Yeah? Great. Jolly good. Okay. Right. Does anyone else have any issues, any burning issues that's causing them problems at the moment? We've talked in the past about money laundering and lack of consistency. There is, Nigel, isn't it? Money laundering. What's the position? Again, a few people have put this to me recently. Two scenarios. Scenario number one, I'm buying a property. I tell you that I've got £100,000 in a building society account. You ask me where that money's come from, and I say I've saved it over the last 10 years. How many people would ask me to provide them with evidence over the 10-year period of my holding this savings account of my introduction of funds into that account? How many people would ask to see a copy of the building society statement or a bank statement showing that there were funds. How many people, if I'm saying I made regular contributions out of my monthly income, would ask to see each and every contribution from my monthly income for the last 10 years? How many people would just take a snapshot and say, well, all right, can I see a bank statement and a wage slip and a building society statement from March of this year, from October last year, and from January the previous year? Yeah, I think that's the point, Loudon, isn't it? Snapshot. I agree. Yeah, I think we're all singing from the same hymn sheet there, which is great. What about if I say £50,000 was gifted to me by a great aunt, and it was gifted to me in February this year? Who would want to see that payment coming in? I agree, Jonathan. Who would ask to see where great aunt got her £50,000 from? So I was talking to someone recently about this, and they said, right, they would want to be able to contact great aunt, for great aunt to be cooperative, and for great aunt to show where that £50,000 came from. And the example I was given was that if great aunt said, well, she was a painter and she painted 5 portraits in the last 2 years, and the commissions and payment for that she'd put into a savings account, and it was that was being paid. So would you want that from great aunt? And then someone else said to me, you'd want to see that great aunt had paid tax on her earnings. And that's the bit that got me, because I think we're all saying the same thing. That needs verification. I agree, Shell, great point. Verification and ID, good, agreed. But would you want great aunt to show us a tax return? Would we go that far? That's the question I'm now putting. All right, David. Yeah, I think I would. Alarm bells might ring. Yeah. No, I don't think I'd be asking about tax. Or I might want great aunt to confirm, ask her to confirm in writing that she'd disclosed it in a tax return and paid tax on it. I might go that far, but I think the point is you do a risk assessment on the client, don't you, first of all, and then a risk assessment on the Debbie like that, yeah, yeah. But you'd also do an assessment with regard to great aunt as well, wouldn't you? I suppose. I think that's how you do it. All right. I know a firm in London that deals with cryptocurrency property purchases, and I've been uncomfortable. Yeah, Charlotte, that would be my view. I would be wary. Now, to be honest, I haven't asked this firm for details of how they do it, but they're, I think, one of the few firms in London that are willing to act. And what safeguards and what measures they've got in place, to be honest, I don't know. I thought, and again, I'm a bit of a dinosaur, but I thought crypto had sort of fallen back a little bit in the running. A couple of years ago, everyone was talking about, and firms were getting geared up to deal with it. I thought it not died a death, but I didn't think it was that common. So, Ian, you're saying you don't touch it. How frequently do you get an inquiry suggesting this is what I'm going to use? That would be my question. And the same with you, David? Not often, right? No, no. Right. And you just declined, David, yeah? So I'm assuming there must be firms that are doing it. Or perhaps not. I don't know. Perhaps we can find out about it. But certainly I would be very reluctant to act because, again, it's the issue of paper trails, isn't it? And you know what would be what I wouldn't even know what a reasonable inquiry would be. Yeah, 2 in the past, right. And Charlotte, this is where the balance of the purchase price is coming from crypto, yeah, rather than it's a cash buy, it's a crypto cash buyer, as it were, yeah. Has anyone seen a lender's instruction that's raised an issue about, you know, the balance coming from crypto? I haven't, but I'm just interested to see if anyone had. It's perhaps something I should ask about. Because my guess is the lender might be worried about it as well as, you know, the lawyer acting in connection with the purchase. Okay. Right. Anyone got any other topics? You haven't seen, but I would imagine there might, you know. Any other topics that we need to look at? While we're waiting for that, just want to show you that we've got Sandra Reid from Pollock Fairbridge coming to talk to us on the 9th of September. 3rd of October, Registers of Scotland. That will be fun. 4th of October, I've got Alan Carton coming along from Carton Consultants. Really nice guy who will be talking to us about his product. And that will be interesting. And again, if anyone wants any speakers to come along, let me know and we can organise it for sort of later, for December and then for next year as well. As far as our conference is concerned, February 2025, and I think we're looking at the sort of second week of February and probably talking about Glasgow. Having said that, I had thought just earlier today, there is a Hilton. Gosh, I want to say it's in Cumbernauld, but I might be wrong. It's on the main road between Glasgow and Edinburgh on the right-hand side on a hill. And I'm just thinking whether that would be a good venue on the basis sort of equidistant between Glasgow and Edinburgh. Anyway, we're working on a venue and working on a date. Would you be interested in a sort of face-to-face event, either a morning or afternoon? Just waiting to hear what people have to say. And the other thing that we're trying to get off the ground is a sort of quarterly publication, looking at cases, looking at articles from all manner of different people that we can ask to sort of contribute. Would you be interested in that? Charlotte, yeah, afternoon preferred. Happy to support online. So actually, Charlotte, it's a good idea, isn't it? If we recorded it and made it available. And Loudon, yeah, I'd be of the view that afternoon might work. Okay, well let's go for that. Okay, let's go for it. And let's get it done. So we're going to go guns blazing on that front on the basis that other than Charlotte, with some justification, saying it's a bit of a hike. I remember years ago I did some work for the Open University in Edinburgh, and I had a student that used to fly down from Shetland. And the seminars used to be every week. He used to fly down. I couldn't believe it. Stay in Edinburgh the night before, attend a seminar, then fly back. Talk about commitment. I also, again in Edinburgh, had a lady. She was 84, and she was a lecturer in French at Edinburgh University. And she started doing a law degree. And the reason she did a law degree, started at 84, was because her husband had died and he was a law lecturer. And she always thought that his lectures were far more fun than hers, and his students were far more interesting and exciting than hers. So she'd always said she wanted to do a law degree. And as I say, her dear husband, God bless her, had died, and therefore she decided to do it. And one of the things was she actually got a degree. I think it took her 5 years or something, but she got it, which was amazing. Never forget her. Okay, right. So afternoons we've got. Right, final call for topics for today. Anyone got any ideas, any things? What's causing problems? What's causing problems? As far as defective title is concerned, again, just so that those of you that haven't attended this event before, be aware that John and Liz and Robert and the team at Stewart Title can provide products covering the issues that I mentioned on screen, but also John and Liz, who are in Scotland, are happy to talk about any particular or unusual requirements. Not including missives until the day before settlement. All right. So the rush job, David. All right. Let's talk about that. Let's talk about it now if you want. What can you do, David? What can you do to prevent it? I mean, surely your hands are tied, aren't you? Conveyancing is a collaborative process. And then, yeah, all right. But it's a pain, is it? Yeah, obviously it's a pain, David. Yeah. John, you put your hand up. Yeah, John, fire away, my friend.
Just wanted to make a couple of points about what has been raised and about what we can provide.
Yeah.
If you don't mind.
Of course
the
not.
Hilton that you're talking about, by the way, Ian, is in Bells Hill.
All right.
Equidistant on the M8, easily accessed. We did have a Japanese knotweed product. I believe Robert knows more about it than I do, but the problem we had for Scotland was we couldn't make it fit the legislation. So there was a product. I don't know if we've still got it. It's still there. As far as tenemental things are concerned, just throwing something out there for people to think about for the next time. What if you've built into the roof space? What do you do then? And literally turning a tenement on its head. What if you've built into the basement and you don't have title to that? Just something that you might want to consider. And maybe for the next time, I happen to be looking at some access issues this week. And a good case to look at is Alvis versus Harrison.
I'm making a note of it.
So it might be worthwhile. I'm just throwing that out there. Time. If anybody wants to do their own investigations further into those things.
Yeah. John, you touched on a really interesting point. I've been doing loads of work recently about airspace development and about subterranean development. So extending cellars, building upwards, landscaping in gardens where you're doing all manner of different removing of surface, removing of rock and all sorts of things. Who does it belong to? So yeah, we'll look at airspace and subterranean development. We'll look at Alvis and Harrison too. Nigel is talking about David's point. Impossible to do anything about the conclusion of missives until the day before settlement. Because if you walk away, there's A, the abortive costs, B, there's dissatisfied clients, etc. And David, I think the point you're making, I guess it really is frustrating. But, what else can we do? Perhaps we'll explore that next time. John, thank you very much indeed for your contribution. Don't start until they get the mortgage offer. Yeah, I mean, again, I can understand that on the basis that if we don't have a mortgage offer, what's the point in doing anything? I get that, David. It's a problem. Well, perhaps have a think about that for next time. I might get someone from the Law Society actually to come along and see what they think about that sort of issue. What I'm going to do now is just show you Elizabeth's contact details on slide. If you have any questions for next time, feel free to drop me a note at the email address. But I am conscious of time for everyone. And I think what we'll do is beat the retreat. I'm just going to make a note of David's point there by taking a photograph of it so we can deal with it next time as well. And all that's left for me to do is once again to thank you all very much for attending today. John, Liz, Robert from Stewart Title, thank you. Everyone that's attended, really appreciate your time. Do spread the word about conferences, about what we're thinking about in connection with bulletins and about future forums, because the more the merrier, to be honest with you. I always enjoy these things because it's amazing what people have to say and how much help there is out there. And as I say, conveyancing is or should be a collaborative process. And if nothing else, this forum does hopefully aid that collaboration. But on behalf of myself and Stewart Title, thank you all very much for attending today.